everyone, and welcome to Nelson Mullins. And for those alum, welcome back to Nelson Mullins. It's nice to see so many people that used to work with us, so it's great to have you here. For those that I don't know and don't know me, my name's Jennifer Malinovsky. I have been with the firm for almost 25 years now, and I practice in the areas of healthcare and commercial lending. And I also have the privilege of serving on the firm's executive committee. And today I have the pleasure of introducing our panel for the CLE. I'm going to start over, actually I'm going to start here since Michelle is doing the moderating. Michelle Johnson is a partner here in the Atlanta office who is going to serve as our moderator, and she practices in the area of employment law. Over here we have Nicole Andino, who used to be with us in the Greenville office until 2018. And she is now Director of Ethics, Compliance, and Social Responsibility at Milliken. So great to have you back. Shaniqua Singleton is a Senior Associate here in the Atlanta office who also practices in the area of employment law. And Doug Spear was here in the Atlanta office for a number of years, and earlier this year he left and became the Chief Legal Officer at Greenlight Financial, which has remained a client of the firm. Thank you, Doug. And now I'm going to turn it over to Michelle, and she will get kicked off with the panel, and I will see everyone on the terrace at 5 o'clock for drinks. Thanks. Good afternoon, everybody. It's nice to see you. And we're going to start our presentation with, here are the presenters. And we're going to talk about several hot topics in employment law and ethics. The first two, which are going to be covered by Nicole and Shaniqua, are diversity, equality, and inclusion, and political expression in the workplace. And then Doug and I are going to talk about ethical issues in corporate investigations and remote work and ethical issues. So, ladies.
I'll stand up here so I can drive the PowerPoint presentation. Hi, everyone. It's good to see you all. Again, my name is Shaniqua. I'm a Senior Associate here in the Atlanta office where I do practice and employment law issues, and over the years have developed an interest and I guess a little bit of an expertise in DEI issues as well, and how DEI issues intersect with labor and employment law issues. So that's what we're going to begin our conversation this afternoon. And Nicole and I were talking beforehand. So if you have questions or comments, please interject. We'd love to hear them and help talk through any issues that you're seeing in your workplaces or in your practices as well, since I know we're talking to a mixed crowd this afternoon. So first, talking just generally about DEI as a concept, it's something that we've all heard a lot about over the last few years. I know it's something that law firms are caring deeply about and have become very invested in. Employers of all sizes and kinds have become very invested in. And the heart of these issues really center, at least from a lawyer's perspective, around this ABA model rule that really provides that it's professional misconduct for a lawyer to, among other things, engage in harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in the conduct in their practice of law. And that is really the heart of what we as lawyers have a responsibility to do in addressing DEI issues. But there are also a whole swath of employment laws that deal with discrimination in the workplace and can affect how we address DEI as a concept in the workplace. You have your general Title VII claims, you have other employment discrimination statutes like Section 1981, you have EEOC guidance, a host of just a body of law and regulations that address these issues. So really, we can boil DEI issues in the workplace and recent hot topics to about 6, I think, general concepts that Nicole and I talked through. The first, and then we'll talk through each of them individually as we go along, but the first being recruitment and retention of a diverse workforce, mental health and work-life balance issues in the workplace, equal pay issues, Me Too and the Me Too movement over the last few years, generational divides in the workplace, and then political expression in the workplace, which is its own separate concept, and we both agreed it could probably be its own separate CLE, but for now we'll try to do it justice in the time that we have here. So from a legal perspective then, talking first about recruitment and retention of a diverse workforce, I think employers of all kinds and sizes really care about recruiting workforces that reflect the populations that they serve. If you're a law firm, you want a diverse workforce because, one, your clients care about it, but two, it really just helps you have a more whole, well-rounded practice and body of ideas that come towards how you service your clients. If you're a company, it's a similar concept. You want a diverse workforce because the people that you service are diverse, and their cares are diverse, and so you want people who reflect those ideas and concerns. But there are also, legal pitfalls and concerns, particularly when you are trying to invest in DEI issues and in developing a diverse workforce and then retain that workforce. There are concerns about unfair treatment and discrimination, and whether individuals who fall outside of those programming or benefits or training opportunities are being unfairly left out of those opportunities. And so that's one thing to keep in mind from a legal perspective. I was reading and preparing for this CLE, a 2016 Harvard Business Review study that found that individuals who fall outside of traditional categories of what we think of as diverse, particularly white males, felt that companies who marketed themselves as being pro-diversity were places where they were most likely to feel undervalued and discriminated against. And so you sometimes hear in the employment law space about reverse discrimination and claims related to whether individuals who fall outside of those categories are also capable of being discriminated against. And I think there are people who have differing views on that, and the case law is differing on that as well. But the general concept is that you want to be mindful of discrimination claims from individuals who don't fall within those categories as you're trying to create a diverse workforce. And then similarly, as you're thinking about what you want to do to create and retain that diverse workforce, for example, having workplace trainings, including DEI-focused questions on applications, investing in internal and external development programs for diverse employees, you want to be mindful that you're including as much language and training as you can about the why we're doing this and documenting the why and making sure you're letting individuals know that the fact that you have DEI questions on an employment application, for example, it doesn't necessarily mean that if it is truly your intent, is going to be what's used to make the ultimate employment decision, and so that you have those caveats and general restraints there and things that will help protect you later on should you be faced with litigation. And I'll let Nicole talk about any concerns from a work ethical.
I'll join you up here. I want to make sure everyone over here can hear me too. So I really well said. I think there's an interesting balance that employers and firms and everyone, they're having to strike in their programming when it comes to having DE&I programs that don't leave certain groups out, and where you're seeing some pushback is if we're doing too much for women, or we're not doing enough for this group, are we leaving other groups behind? And so I think a successful DE&I program has to look holistically at culture first. I think a lot of employers, when DE&I really became a center of focus in 2020, and even before that, starting in 2016, the social injustice movement really got it in the spotlight, and then people started focusing, well, what can we do, and training, and what can we do to make sure that the mental, and we'll get to, people's mental states are heard. But I think the culture and going back to the root cause of what's causing the retention issue has to be looked at. That's one of the hardest areas to measure in inclusion. So people automatically go to diversity metrics, hiring metrics, setting quotas, getting in trouble for those quotas, and because you can't just put out those numbers and then have groups. I mean, I think we had a big lawsuit out of North Carolina. I can't remember which healthcare company it was, but that executive was terminated, was backfilled with a diverse employee, and he won his lawsuit. I'm sure it's in appeals because it was a huge verdict against that healthcare company. But that company was, I did not dive into what their programming was, but they were probably a little too focused on diversity metrics. And so you need to look at culture, you have to look at training, but not just let's get together to meet this mandatory training that gets to the root cause issue of what's going on in your company or what's going on at your firm. And that all takes work, resources. And I think that's where DE&I lacks in some areas. We have a big focus on it for certain periods, and then it kind of dwindles and then comes back when we see attrition rates going up. And I think that if we have a holistic approach to it, looking at culture long-term, focusing on people goals, which is one of my areas under social responsibility at Milligan, those long-term 5-year, 10-year plans, you'll be more consistent and not just focusing on let's hire, let's get the diversity up, because that's not going to help with retention at the end of the day, that especially with employees today, they're looking for more from employers than just this is where I need to draw a check. They're looking for values. They're looking for something long term where they feel like, oh, I belong here. And so creating that culture of belonging, it just takes some effort.
Yeah, and so then turning to the next two really key hot topic areas in this space, mental health and work-life balance. I put it in quote because we all know balance sometimes can be a little bit of a misnomer there. And then equal pay issues. Employees, I think, increasingly are especially asking for what is the company doing to improve mental health and address mental health. I think we all know that employers have an obligation to provide reasonable accommodations when employees have mental health concerns that rise to that level that affect their ability to do their job and perform their job duties as stated or written, or however it is that the company has come about developing those job duties and requirements. And we all know that employers have an obligation to ensure that their employees are being compensated in a way that doesn't run afoul of employment laws. But I think practically a lot of employees are also asking, so beyond that, before it arises to litigation or an issue that will require some kind of legal involvement, what are you doing to address mental health issues? And what are you doing to ensure that women or diverse employees are compensated equally to others in the workplace? And I think, from a legal perspective, you want to be mindful of those concerns because, to the extent you're in your workplaces and you're hearing musings about people feeling like, their mental health concerns aren't being cared for, or considered, or they feel like different people groups are being compensated differently in a way that runs afoul of employment law. Those can be buzzwords and concerns that might lead to litigation down the road, either on a mass scale or individual one-off claims. They can also lead to something that we'll talk about later in our presentation, which is about generational divides in the workplace, political expression, and how employees are using social media to voice their concerns about these issues. So you don't want to find yourself on the wrong end of a TikTok video or some kind of social media tirade about these issues. So you want to be making sure that you're keeping abreast of them, keeping a pulse on what your employees feel about these issues and how you go about addressing them.
That's right. I think on the mental health side, the trend that I've been seeing and keeping an eye on is what employers are doing to create access. You see a lot of employees suffering, but does management know how to identify those issues, or are they going straight for a performance improvement plan and working that person out? And I think we can, back to retention, you can work on accessibility to programs so that it's not affecting certain groups more than others that don't have access. So one thing we're doing is making sure benefits programming, EAP, is in multiple languages. Our employee population speaks about 7 languages, more than that, but the main population speaks about 7 languages. So, and getting that all translated isn't cheap, but it's an investment we're making to make sure people know what's available to them. There's other corporations like Starbucks offering Headspace. I'm sure you guys on Teams have noticed that Microsoft now offers the wind down and focus time. That's so you can try to focus, and then wind down has a meditation component. You can see it integrating into a lot of aspects. So this is a growing trend, and focusing on mental health may seem I don't know, some employers think, oh, well, what's the big deal? Well, if employees feel like they can't be productive and employees feel like they're not being heard, that can increase ethics concerns and other issues in the workplace. So taking a stance there, and I think having some programming in place that's being communicated effectively with access to different groups really goes a long way. And then for pay equity, I think the trend I've been seeing a lot, and I'm sure you guys have seen these laws coming out, is pay transparency. Employees really want pay transparency, and states are actually following their lead and having pay transparency bans come out on job descriptions, which is much harder than it seems. You think, oh, let me just put, the bans can actually be pretty broad. And if you don't have job descriptions that are drafted very narrowly, which at a law firm can be easier said than done. At a corporation, you've got tons, like over 200 job descriptions. You know, that can get really difficult depending on people's areas of expertise. And so it's really balancing, carefully balancing, how can we get wage transparency out there when we're conducting audits while maintaining privilege over those audit results. That's where there's a real struggle to find that balance. I think, and finding the balance to meet those employee demands. Because again, I think that the bigger trend among all of these topics is retention. Employees that don't see that pay transparency or don't see these DE&I initiatives are more likely to move on one way or another. So I think that's when I was a director of DE&I at regional and also associate counsel for them, that was one of my biggest struggles, was maintaining privilege over what we needed to keep confidential and what we needed to address, getting to the root cause analysis, making sure to work with outside counsel on that, and then also meeting employee demands to be transparent. Of course, we're conducting these audits. We want to have competitive pay. We want to have equitable pay. We want to retain talent, but how to do that while maintaining balance is really the key.
And so the next, is something that I don't think has come up as much in the last few years as it had when Me Too issues first arose, but it's, dealing with Me Too issues and complaints about, sexual harassment or any kind of harassment in the workplace and how you go about addressing those concerns. We can all remember, the complaints of a few years ago where you had really big, prolific, high-profile individuals being fired or placed on leave from companies because of these issues. And even it can happen in the smallest of settings. It can happen in law firms. It can happen anywhere. So from a legal perspective, when you are faced with some kind of Me Too allegation or allegation about harassment of any form, you want to be sure that you're taking those complaints seriously. You want to be sure that you are ferreting out where the heart of the complaints are and any kinds of he said, she said issues, which it can be hard to boil down to those kinds of things, but making sure you're getting to the heart of the complaint and the issues and not just, gossip in the workplace and what might be rumored to be true. And then thinking about, from the very beginning, when you receive those kinds of complaints, how the company is going to go about addressing it and building your defense to those claims. Because even if it is a complaint against a single employee or maybe a group of employees about an issue, it can very quickly turn into litigation against the company overall and concerns about what the company knew, when, and whether or not they allowed the individual to continue in the workplace, continue in that position of authority if they have one, things of that nature. So you want to be sure you're looking then holistically at policies, at your training, at how you're going to investigate those claims, and then how you're going to take action to address those claims when they do arise. And then moving to the next issue about generational divides in the workplace, thinking about the various groups of individuals we all have in the workplace. I think for those of us who are at the firm, we might remember at the retreat the slide that showed just how many different generations we have working across our firm. And even now, I think you have what people think of as Generation Z being a part of our workforce, and how those affect what we do in the workplace can affect DEI policies as well, right? Because not only do you have individuals falling in that Gen Z or early workforce population, but you also have individuals who are staying in the workforce much longer than they might have in the past. And clashes between those groups can lead to their own kinds of legal concerns and pitfalls and considerations. You might have discrimination claims related to issues coming up between those groups. You might have, again, concerns with younger generations feeling like it's okay to say certain things in the workplace or express themselves in certain ways or share information on social media or other platforms that might be sensitive to the company. So then, again, being mindful and looking at how you're going to address those issues when they come up on the front end can really save you a lot of heartache on the back end and hopefully avoid litigation or any kind of large-scale legal issue when those come up.
That's right. I think it's right on. I think employers are focused on those defenses, not just as defenses, but as most of their compliance programming in this space focuses around the sexual harassment training. Some states are requiring and mandating that training, 2 hours of training for managers, which goes more in depth than the employee training, which is typically on 45 minutes to an hour. And it's something I've seen on a global scale too. We have sexual harassment training requirements in Germany and other countries. I think to go a step further, the foundation there being expanding that training and focusing on ethics, respectful communication. What are your pillars of ethics at your firm or your company? Respectful communication and the importance of inclusion. Those have been, if management and other employees have those foundations, those have been tied to reducing harassment claims, not just sexual harassment claims, but especially respectful communication being one that's gotten out of control with remote work, and being mindful of that type of training to cut back on some of the harassment claims that we've been seeing. We use a third-party monitoring system and NAVEX for reporting, and they come out with benchmark reporting, and harassment is by far the highest report they're getting from millions of employees worldwide that they companies they represent. So it's still a big issue. I think people see Me Too as a 2016 issue, but the Weinstein trials are going on right now, and this isn't going to end. It's not just a quid pro quo issue. It's not just let's put out some sexual harassment training, we're done. I think it's a deeper, it does tie into generational. I think it's a deeper need from employers to really speak up on what are we expecting from our employees in terms of ethics, what are our pillars of ethics, integrity, and having that respectful communication and inclusion. That'll go a long way across the generational divide in the workplace right now. I think the communication aspect is the key trends there. Seeing an uptick in harassment and bullying claims, and it's not really bullying, not to discredit claims coming in, but it's just usually can be root cause misunderstanding communication, because some people prefer email, other people prefer in-person meetings, and making sure those two people can meet in the middle, especially in this remote work environment, is somewhere where employers are just going to have to put more work into in that space. I mean, there are, like you said, 5 generations in the workforce, and management's just going to have to take that extra step to learn what does each generation value, because the values do differ greatly between the generations. We're having a 3-part series on this right now at Milliken, and how managers can speak to the different types of needs and values that employees want, and all of that will tie back to retention as well.
And then finally, on the DEI topic and employment law issues is the one that's probably the most salient to us right now as we look towards a general election, and that's political expression in the workplace. I think over the last few years, particularly with George Floyd issues and other issues that have come up socially, people want to be able to talk about their beliefs socially, politically in the workplace. They want to be able to talk about those beliefs outside of the workplace, but it can raise big issues for employers, and one of them being particularly as people are more open about their political beliefs and their social beliefs, they're more willing to talk about them in the workplace, and they think they can just say whatever it is they'd like because they're protected by the First Amendment or other kinds of laws of that nature. And I think we say here the First Amendment myth because it really is a myth. It's not, the First Amendment isn't a wholesale protection and allowance for you to be able to say whatever it is that you want. And so employers have to be really mindful about what is the speech that's being said, and is this something that goes against our internal policies and codes of conduct for employees, looking back to your employee handbooks and things of that nature to make sure they're shored up in addressing those issues. And then the other issue is, employees feeling like, okay, if I can't say whatever I want in the workplace, surely I can say whatever I want when I'm no longer in the workplace and I'm off duty, or when I'm on my TikTok page or using my Twitter page. And that's also not necessarily true. I think we've seen a lot of high profile cases lately where individuals might have said something on a social media platform or in some other setting, and it has resulted in some kind of adverse action at their employer. And whether or not that is something that ultimately happens, it's something that the company needs to be mindful of what's our core values? What do we care about? What do we want to regulate? What do our internal policies and employee handbooks say? And how are we going to address this conduct as it happens? Whether it's in the workplace or outside of the workplace. And then, again, with other issues, harassment and how individuals who have differing beliefs in the workplace express those, and whether or not those can lead to harassment claims because someone has been overbearing with their claims or created a hostile worker environment because they are a manager and have imposed their beliefs on their the employees to report to them, things of that issue. So it can raise a lot of just differing concerns that we don't necessarily think of because we think people are just speaking and they're allowed to speak, but that's not necessarily the case.
Yeah, I've seen this come up in various forms where management or other employees are saying inappropriate things at work that's carrying over into social media, or they're on the premises streaming on TikTok inappropriate things on social media inadvertently, usually gets reported. We push a pretty hard speak up culture. So there are some employees speaking up, we review it. We're not actively monitoring, and at Regional is the same way. At my past company, we don't actively monitor employees' social media. So they could be saying stuff, but if it's brought to our attention, there is action taken. And it really does surprise some employees, even though it's so clear in the global social media policy, in our communications policies, electronic communications policies, that what you do and say, if it represents the company, sometimes it affects customers and they are the ones that are reporting it. They think other employees are the ones that ratted them out. No, sometimes it's customers coming forward. All of that sheds negative light on the company or the firm if you don't take a certain action to address that kind of misconduct. And where I see probably the most heightened adverse action that results is when there's violent stuff being perpetrated, or it's people think, oh, it's just an innocent meme I shared. Well, it shows a very violent depiction of what you expect at protests, then yeah, that's not something that is in line with our values as a company, and so we don't tolerate it. And then we usually use that as a case study to communicate that intolerance so that other employees know you post on social media, when it gets back to us, is addressed, we care. Same thing on no tolerance for discrimination issues. There's been a huge uptick on social media of racially triggering words. And I think that's something employers need to be mindful of, that when employees leave the premises, it doesn't mean our ethics, integrity, and values that they're representing from 8 to 5 go away. And that is quite the burden, but that's what's expected. It's not just during the workday.
Yeah, so we'll pause here in case anyone has any questions or comments on this particular issue, but I think a lot of it just boils down to common sense really in the workplace, and just making sure that when you are approaching DEI issues, it's not anything that I think requires a lot of legal mastering, but it does require some thought and requires some good planning from a company perspective, from an internal law firm perspective, to make sure you're doing it right. And if you're going to have DEI policies and initiatives, making sure that they aren't running afoul of existing employment laws and are truly something that benefit your workforce. So if no one has any comments or questions, I'll turn it over to Michelle to move on to our next portion of the CLE, and thank you all.
Tanisha and Nicole. Our virtual attendees that are with Kimberly Clark and Western Union
need to record the following word into the survey that they will be sent following this presentation. The word is November. And there'll be another word at the end of the presentation. So our next topic is ethical issues and investigations. And Doug and I are going to tag team this one now that he has been both in-house counsel and outside counsel. He has seen it from both perspectives. But first, let me ask the rest of you, how many of you have experienced an investigation where legal counsel was required? So, okay, quite a few. That's good. You're in the right place. So I guess the first question that comes up when you have an issue is legal counsel necessary? And I guess, Doug, what are your thoughts on that?
Thanks, Michelle. First of all, great to be back. Great to see so many friendly, familiar faces. Second of all, this is the longest I've ever gone without talking in this building in my life. I have learned when you go into a new position where you have a lot to learn, you learn to listen. So I'm learning, and it's hard for me. I'm learning to become a good listener. So today speaks volumes for that. To your question, so in investigations, in private practice, I only had clients call me a handful of times over 23 years to talk about matters that really required either an internal investigation done by the client, or in some cases, an external investigation done by us or another third party. Already at Greenlight in 6 months, I've dealt with 2. And in fact, I have one ongoing right now. I think, it's really important to pay attention to what claims are made by a large, growing, and diverse employee base. I think, your policies, your employee manual, that stuff really matters. I never knew how much it mattered, but I am amazed every day to find out how many people actually read this stuff and go to. We use it at Greenlight. We use a piece of software called Namely for a lot of our people ops. It's a fancy startup word for HR. For a lot of our people ops functions, and we keep all of our policies and procedures on Namely, and people are hitting that multiple times a day, every day. How many of you have looked at your law firms or your company's, policies or procedures? I doubt very many, right? But I'm telling you, especially to Nicole's point about younger workforce, they're looking at it all the time. They are. And so you better make sure it's sharp. You better make sure it's fulsome, and then you better be receptive to listening to claims and hearing people and considering whether an investigation is warranted, and if so, what type of investigation, and when you need to call in outside counsel like the good folks here, because for me, I didn't grow up as an employment lawyer, and now I am most certainly our head employment lawyer. So I'm calling for help a lot, but that's important.
And I think it is important to think about the type of investigation it is, and do you need someone from outside who is not part of the company? And maybe that is what you need. And then there's other times when it just feels uncomfortable to bring in outside counsel, and in some cases, some circumstances, you want to leave it inside, maybe with your in-house attorney or your HR department, and it varies. And sometimes you have a hybrid where the in-house department gathers the facts and then brings them to the outside counsel, and the outside counsel discusses the conclusions and maybe what are the next steps, and what reparations need to be made.
I was gonna say, for the investigations that I've been involved with since I've started, our process has been people ops team will conduct an internal investigation first, see what they found, and then depending on what they did or didn't find, we'll determine whether we go to the next steps of conducting an external investigation and what that might look like.
Well, the other thing is that your external investigation can take a lot of different approaches. I've had investigations where I was called on Monday after something happened on Friday, and I did a couple of 1-hour interviews, and that was the end of it. Reported back to in-house counsel and said, here's what I found, here's what I think you should do, and that was it. And on the other end of the spectrum, we've had investigations that lasted 6 months. So, it really, there are a lot of approaches that you can use. I think an important question, who is the client? Because, when you're talking to that employee, who do they think is the client? They think it's them. They think, well, you're my lawyer, you're the lawyer, you represent me, right? And so it's super important to make sure that everybody knows the client is the company. And we often tell employees that if they want to get their own lawyer, they can. And, we give them that option. And they never do. Never. I can think of one time when we had to stop the investigation so the person could go get a lawyer, but that's rare.
I sometimes feel like the lawyer's lurking in the background, though, when you see certain emails come over, and you think, the employee probably didn't write that.
Yeah,
Now that is true.
I've seen that email. Yeah,
It's almost more scary.
it is. Yeah.
Exactly.
I wonder who they've hired is the first thing that comes to mind because the legalese comes out fast. I'm sure the employment attorney hired probably thinks, oh, just send this. It's pretty innocuous and it documents this. But if you're reading it, I'm like, that's a word. No, there's no way. There's no way.
Right.
So it's like lawyer already.
Right. So some of the language really is a key that this is not coming from the employee.
And then does that change the investigation? Once you know there's an attorney involved, then does it heighten the investigation for the company? Oh, this isn't just any kind of claim. This actually a serious threat. Not that all claims that don't come in are a serious threat, but it definitely brings it up to another level.
And so let's talk about confidentiality concerns and the attorney-client privilege. When an employee, a rank and file employee comes in and they tell their story, the company policy is typically, you need to keep this confidential. You need to not talk about this outside of this room because we want to protect the integrity of the investigation. Shaniqua and Nicole, is that what you tell your witnesses?
Mm-hmm. Yep. Because I think, from the witnesses' perspective, they don't necessarily feel like it needs to be. They want to be able to share their concerns with you, but they also want to be able to share their concerns with their colleagues, with their loved ones, with other individuals who they feel like either need to know what's happening or they feel like might have information to add to it. And so they want them to know that this investigation is happening. And so it's something that you have to definitely be mindful of at the outset. This is a confidential investigation. And it will affect the nature of the investigation if it is no longer confidential.
Yeah, we try to be pretty transparent about what's going to happen in the entire investigation, not just for the reporter, but any witnesses, so that they're aware that anything they go out the room and say could affect. It's like, we're not just interviewing you, we're interviewing other people. We could only be interviewing two, but they don't know that. And so just saying that generally, it could get back to us if they're going around talking. And that usually dissuades a lot of conversations, but in reality, employees talk. And this usually actually hurts. It's another area to balance. It sometimes hurts reporting because people are like, oh, the reporter got back to me. Everybody on the floor knows that I made this claim. Well, they don't know who made the claim. They know we're investigating a claim. They know that we care about this claim. So really highlighting the positives there, because confidentiality is so important sometimes for the reporter. Other times the reporter will give you a list of 20 people to go interview, and they're not as concerned with confidentiality as others, but some fear retaliation, and that's where having a non-retaliation policy in place goes a long way, and reiterating the importance of that.
I think there's also a concern about morale.
Yeah.
Right? Like, how do these investigations affect morale? You want to make sure that you conduct a thorough investigation that gets to the heart of the claim made. At the same time, you don't want it to take everybody down from a culture or morale perspective. And that can be very challenging, and confidentiality, I think, is a big part of trying to maintain that. At the same time, you have to recognize that people talk, notwithstanding your best efforts to get them to keep things confidential. So it's, I think I found that one of the most important elements of an investigation, therefore, is speed. Doing it thoroughly, but doing it quickly, getting it over with, figuring out what the result of the investigation is, and then taking the appropriate action. But letting things linger is usually a recipe for disaster.
And I will mention one other thing, which is the National Labor Relations Board takes a slightly different view, which is that non-management employees who are required to keep an ongoing investigation confidential may have a basis for an unfair labor practice claim. And what I advise my clients is you ask for the confidentiality, you explain why it's so important. But with non-management, if you require it, you're really skating a thin line that you may end up with a charge. Now, with management level employees, there you go. So with management, of course it's fine. You can keep management quiet all day long. The other thing is that it's not protected by the attorney-client privilege if you have a witness who is not part of management and you are not representing, then there is some risk that if the things that they say may, they're not privileged, and you really have issues with contaminating the investigation and deterring people from coming forward for the reasons that Nicole pointed out. So as far as protecting the attorney-client privilege, okay, well, when you're talking to managers who are part of the C-suite, they're part of the company, and so the things that they say to you they're privileged, and they're privileged until someone reaches the privilege, and that's why it's so important to maintain that and to warn your managers that it's really important. The things that you say to your attorney, you don't go home and say to somebody else. You please don't say them online. Don't tell your friends. Don't talk to anyone who doesn't have a need to know.
Don't write that email.
Yeah.
Don't forward that email.
Yeah.
I think attorney-client privilege, at a law firm is a much simpler concept than attorney-client privilege within a company. Not just specifically to this issue, but when you're at a startup like I am, and you're dealing with the intersection of business and legal issues all the time, a little bit too much business in that communication might mean no attorney-client privilege. And I don't think it's not something that I appreciated before I started. And it can make, if you put it in the context of a claim or investigation that is about a specific claim, specific issue, when people start talking about things that are related to the business that are unrelated to that issue, you may have blown privilege and not even known it. So it's something that I think requires focus and attention if you're trying to make sure that people understand that there's this privilege that you're trying to protect. You need some guideposts around how to do that.
Yeah, and I think Nicole and I were talking about this issue before. It really comes up when you have individuals who are working internally for your company or at the firm who have dual or maybe triple roles like Nicole's, right, who are investigations counsel, but also in compliance, but also in-house legal counsel. And how do you walk that line between which hat are you wearing during the investigation? Is important to making sure you're keeping clear communications or having one other person who's purely in a legal role in the room so that it is privileged can go a long way.
That's right. Yeah, when I was sitting, I'm kind of in a dual role now, but at least I'm fully in legal, so it's a little easier to maintain privilege. But it gets tricky if you start talking business and really getting the training out there, especially to HR, because they might email me on two issues, one that requires more sensitivity than others, and so really talking to them each time that happens. In the DE&I and associate counsel role, that was especially tough. If a reporter came to me, I would engage one of the other attorneys to conduct the investigation because they were coming to me, I thought, as the person pushing inclusion and DE&I, an open door policy, and that was very difficult to balance because you're still representing the company as their employment counsel. So I would bring in the general counsel to talk to them, and then the HR to conduct the investigation unless HR was involved. If anybody at a certain level for HR was involved, we usually did bring in outside counsel for those, just to make sure the integrity of the investigation is there.
So let's talk about, what have I done wrong? There we go. Okay. Going back to a couple of ABA rules. Attorney-client privilege and employment law matters. Clearly, what we've been talking about, a lawyer shall not reveal information relating to the representation of a client without informed consent, unless an exception applies, which is the lawyer may reveal information relating to the representation if it's necessary to resolve conflicts of interests. And there are a few other exceptions, but really I think the important thing is to assume that if you say something to an outside party in the course of an investigation, that is likely to waive the privilege. So, and then with respect to outside law firms that are doing investigations and the responsibility of managing lawyers over, managing an associate, the rules under the ABA model rule are pretty much if the managing lawyer is responsible for the people that work for that lawyer. And so if you have direct supervisory authority over someone and fail to take reasonable remedial action, that can be a violation of the ABA rules. So we're going to turn now to remote work and ethical issues. And I assume that all of you have either worked remote or have other employees that have. Am I right? Okay, so we've all, especially over the last 2 years, we've all done some remote work. And so I think the first thing that comes to mind when people are working from home or working from the coffee shop or not coming in, working from some outside location, how do you protect the company data? And Doug, what do you do at Greenlight to do that?
Well, just to set the table, so Greenlight has 550 employees. We have one office here in Atlanta. More than half of those employees were hired during the pandemic, meaning that they were all hired remotely. Many of them work outside of Atlanta, meaning that if they wanted to come to an office, they couldn't. So I call it a distributed workforce. And then if you're in Atlanta, you sort of feel like, well, nobody else is coming to work. Why do I have to come to work? So you put it all in the pot of soup, and what you have is a company where most people are working remotely wherever they live. I think our IT department has done a really good job using tools like Okta and other pieces of software that help us work, remotely. Everybody gets a laptop your first day. They actually FedEx it to you, so you're not coming into the office for training. There's no Columbia to go to, you sort of grow up that way. It's part of the culture of the company to be remote, which was very different for me. Still is in many ways, but it's not that hard to accomplish if you're thoughtful about it. From a data perspective, it's actually, I think we, so far so good, have been pretty lucky on the data side, and we have people working everywhere, and across the United States, across the world. We just opened a development center in India for software engineers. So I don't think in today's world it's that hard to protect your data if you are thoughtful.
So do you give them like a secure Wi-Fi, or trust that they're not using like the Starbucks Wi-Fi?
The latter. We balance the cost of spending on a, when you're at a company, you can't pass all your costs on to your client without them knowing. Wait, this is an ethics seminar. When you pass all your costs on to your client, it's a lot easier to be thoughtful about that. But when you're in a business and have to make real world decisions, balance, risk versus expense, on things like that, you sort of say, hey, be smart and don't use a public Wi-Fi when you're working or using your work laptop. But yeah, no company hotspots.
Nicole, what do you do at your company to protect the company data for people that are working remote?
Okay, so I think it was coming to a manufacturing company, the risks are different than when I was at a finance company. There, everyone had the VPN access to make sure that when you are offsite, you were on the VPN. It was more secure that way. Really built up a strong data privacy team. I think at Milliken, the focus is different. It's mostly manufacturing. I'm making sure the IT team is very focused on, and we're on site. I mean, we've required a lot of employees to come back at least 3 days a week. But when they're off site, if they're taking any sensitive information, that is usually limited. We try not to allow that, especially if it comes to the finance department. But it's definitely, I've noticed since I started, it's a big difference at a manufacturing company versus what we were doing and the links we were going to at the finance company to protect our information with remote employees everywhere.
So what about your out-of-state remote workers? Do any of you have employees that work in another state? So away, and so you have your home office in one state and you have employees working other states. So probably a lot of you. And if you have employees that work remotely, have you ever had somebody move and not tell you?
Yes.
So, and that creates all kinds of issues. If you have somebody who's wandering and they've gone to another state where you don't do business. And so when somebody moves to a state where you don't currently do business, what do you do? I mean,
You call your tax department and then they yell at you.
Call outside counsel. We've got an employee in Brazil. What do we do now?
I had happened to me today. Somebody called and said, so-and-so is in Mexico. And I said, I hope he has a good trip. They're like, no, he moved to Mexico. What? Yeah, you can't just move to Mexico. And I found out, he cleared it with our people ops team because he's again, to the concept of balancing risk and reward. Well, he's a really good employee and we really wanted to retain him. And I'm like, yeah, I wish somebody would have called me because now I can clean up the mess.
Yeah.
It's and some messes can't be cleaned up. So that's when you call outside counsel.
That's right.
Yes, so outside counsel. It's more than the tax issue and how they're getting paid at the end of the year, where it's getting split. It's also going back to data privacy, especially now going from a national company to a global one. The data privacy laws vary, their protections vary. Oh, by the way, I forgot I told you, I moved to France. Well, they have a lot of parental leave rights. Do we have a policy for that? So training HR, especially when remote work started, and I mean, these issues really didn't come up at first. I think they came up really towards W2 season.
And there's security concerns. Certain countries, are on the blacklist, and you don't want employees living in those countries with the ability to access your data. So that also happened today.
Man, you're really busy.
Don't believe me. But it's thanks, Charles. These are real issues and they're complicated. And if you have a distributed workforce, and I don't think this stuff is going away. If anything, it's going to become more commonplace. And look at the benefits of it. I mean, you can hire the best people in the world at what they do, within reason anywhere. And you're not limited by geography. I mean, that's huge for business.
what's your pay transparency band then? Just to tie it back to that earlier discussion. I mean, that's so difficult.
Right.
Because that's exactly right. You're hiring talent globally. And then there's a few states that are saying, oh, put a pay band on that. What?
Right, it's a real issue, and this, for us, the pay transparency stuff, because it's all pretty new now, right? So it's stuff we're getting our head around. But yeah, I think these are all real, there's lots of new issues that are popping around because of remote work that I don't think everyone considered, when we first were all, we went to remote work to survive, right? But now we're talking about remote work to thrive, to stay. That's very different.
So let me ask somebody in the audience, a volunteer, about what did you do when you found out somebody had moved to a state where you didn't currently do business? Now I saw some hands. Anyone? Jenny, did you say that it happened to you?
We actually are in most locations, so I didn't really have to worry about that. But
Okay.
I mean, it was the same issues that Nicole mentioned. You got to make sure their taxes are updated, that you're, for unemployment purposes,
Policies.
like the right policies are applied to them.
Well, and then overtime laws are different in different states. You've got the leave laws.
Restrictive covenants, you might need to have
Yeah.
a new restrictive covenants agreement.
You got to register to do business in that state. Telework, I mean, you've got expenses in California. The expenses you have to pay for telework are different from the expenses you have to pay in most other states. So, yeah, it can be a mess. And so moving on to wage and hour issues, it's a lot of the same things that we've talked about, that different states have different minimum wage, different overtime requirements. There are different exceptions from overtime. Some states have exceptions for computer workers, like under the Fair Labor Standards Act, and others don't. And so you have to make sure that you are keeping track of state laws in all the states where the employees are, as well as the federal law. Then what about timekeeping for your non-exempt employees? How do you all, let me have a volunteer. How do you keep time when you have people working remotely that are non-exempt?
Keep their own time.
How do they keep it though? Do they keep it on an app? Do they keep a timesheet?
There's no software.
And what do you do when they're off the clock, but they read an email or they take a call? I mean, what do you do then?
That you know of.
What?
That you know of.
That I know of. Fair enough. Well, for one thing, non-exempt don't have access to it. So they're not going to be checking. I mean, it's really left to them to honestly.
And I mean, have you had cases where people said that they worked off the clock and had to address that?
If it came up, they could be the VPN access. Yeah, they could look at activity on the computer. IT could look at the activity, and based on their representations of when they worked and forgot to clock in and stuff, we could look at activity on the VPN and try to connect it. Because I think, if I'm remembering correctly, the data and timekeeping system is you can only access through the VPN system, so it's monitored by IT. They changed that?
Well, it's not working.
Oh man, see.
Well, what about people who take breaks during the workday? I mean, Doug, how do you keep up with non-exempt workers when,
We have a new policy in our company that unless you can justify it, you're not allowed to have a meeting. So, which is very different. Up to that point, my calendar would have 10, 15 meetings a day, every day, 30 minutes. But many of which weren't really necessary. So we just changed it, said no more meetings. We flipped it, said you want a meeting, you have to justify. You have to have an agenda and you have to have a real reason to have a meeting. I'm not sure it's a great policy either. I'm not sure there's no perfect good, but in that case, we're going to have a lot of people, with a lot more time to do whatever they want. I mean, the theory is we're all big boys and girls. We can take our work seriously and get our work done. But some people aren't. Some people aren't going to do that, right? So there's going to be people, and no one's going to verify your time other than if they wanted to back channel it, as you said, checking the systems. But you can only check so much there. So I think a lot of it is still based on trust and focus and everybody shooting toward a common goal. I mean, we have so much to accomplish and so much to do. The thought of people taking advantage of the system is almost comical because we'll figure it out really quick because we all have more to do than we have time to do. But that might not be the case in a bigger company or a company that has been around a little longer. It might be harder to figure out.
So how do you keep track of employees who are, they say they're working, but they're not there, you can't see them? So how do you manage to determine if somebody is laying out and not doing their job?
I think managers typically know when people are, it might be more challenging for managers to have larger teams with a remote workforce, but most managers know when people are not being productive. And you start putting a management plan. I think Ford just announced this actually. People with less productivity were getting put on 6-week management plans, or they could accept a severance package. And they're trying to address quiet quitting that way, which is an interesting concept. And I'm surprised because I don't see quiet quitting as I'm not working. I see it as people trying to impose work-life balance and boundaries. But some people see quiet quitting as I'm going to do less, I'm going to work less hours, not less hours, but say I'm there 9 to 5 and only work till noon. And that's what they're trying to monitor. I think a lot of companies have put systems and monitoring in place. Some companies are still using the trust, and I think it goes back to the size of the company. And if you can monitor with software in the background, let the employees know and then use the software. And I think that's what you're seeing at some collection centers and stuff like that, but it just depends on the type of workforce.
Well, have any of you in the audience experienced somebody who was overemployed, meaning they had more than one job?
Oh, yeah.
Lots of Uber Eats drivers during the pandemic.
And then what do you do? I mean, do you let them work, have more than one job? Do you require that they get permission before they take the second job? Do you have any guidelines with respect to people with other employment?
We don't, which we probably should have, but the easy thing for us was that this was clear that they were not working a full-time job for us and also doing their side hustle, so that we managed it that way, but setting their expectations on time, what we expect of them, certainly after hours on the weekends. We do have people that have other gigs that we're with. It was more saying you were doing your recruiting job while you were also
So the other topic we haven't touched on yet is employee injuries while working remote. And I can tell you, as a matter of policy, OSHA is not coming to your house. But you do have to have a workers' comp policy that covers people who are working from home, because if they get hurt while they're on the job, then the company's on the hook for that. So word to the wise. So anybody have any? I see that we are actually, oh my gosh, we are moving close to that 1 hour time we need for our ethics hour. So let me move right along. Let's see. You'll have to do it again. Oh, thank you. Excellent. Okay. And this is just a quick note on attorneys who work remote. This is the ABA rule, which is that lawyers may remotely practice law in jurisdictions where they are licensed while physically present in a jurisdiction where they're not. And there's a lot of guidelines around that. If the local jurisdiction has not determined that the conduct is the unlicensed or unauthorized practice of law. If they don't hold themselves out as being licensed to practice in the jurisdiction where they are living, if they don't advertise or hold themselves out as having an office, and they don't offer to provide services in the local jurisdiction. And anyway, lots of issues about that, which came up particularly during the pandemic when there were a lot of people who were licensed to practice in one state, but they had a vacation home in another state. Maybe they spent some time there. And so what the ABA says is that is permitted with certain guidelines. And Charles Huddleston is going to tell us how this rule differs from the rule in Georgia.
Georgia proposed formal advisory opinion. This comment period ended last week. I checked with my friend at the state bar, and didn't get any comments. So it'll probably be filed with the Supreme Court and be published again. It's very similar in terms of as long as you stay invisible, don't hold yourself out practicing law. They list some examples of how you might violate this rule and be then engaging in unauthorized practice of law in the state where you're not licensed. And that is, you do not reveal your Georgian location. This is somebody who's not licensed in Georgia. In advertisements, on letterheads, on business cards, through the use of a local phone number or by any other means. So when you're playing golf and somebody says, what do? You can say you're a lawyer, but it better be quickly prefaced with that I cannot practice in Georgia. Because otherwise, innocent people will assume, well, you're a lawyer, I can ask you legal questions.
That's right.
Be friendly, you might try to answer. Well, right there, you're committing an unauthorized practice of law in Georgia.
Thank you, Charles. So does anyone have any other questions? And I will say, if you want to, you can hold that question, get a drink, and we can talk about it outside. I'm sorry. Oh, the last slide is our virtual attendees that are with Kimberly Clark and Western Union need to record the following word into the survey they are sent following this presentation. The word is 5. Yeah, Charles?
I was going to add one other thing. I think the biggest myth about First Amendment law, this does apply to private. It's only protection against government action. So unless you're working for the government, boy, so I got First Amendment rights. They don't really have First Amendment rights outside working for the government.
Well, what they say, the First Amendment means you're not going to be arrested for what you say. You're not going to be thrown in jail for having an opinion and expressing it, but that doesn't mean you won't get fired. So thank you, everyone, for being with us. We appreciate your time and your attention, and we invite you to the patio to go have a drink. Thank you.